Ladies and gentlemen, welcome to the second webinar. My name is Nobesu Tuchai, and I am the executive producer of the National Arts Festival. The second webinar stems from the first one that we had, where we were talking to artists and talking to our stakeholders, explaining to them that the National Arts Festival is going virtual. So we're basically responding to your questions as to why are we going virtual and what this means. So there were a number of questions that stemmed from that, where people wanted to know the issue of copyright, licensing, and royalties, because people want to be part of this festival, but they're very protective of their work and they don't know how this new platform is going to work. So the festival then decided to have this second webinar, but this time around we have people who are experts in the copyright, licensing, and royalties issue, because to be honest with you, as the festival, we are not experts when it comes to this, but we've got you covered. Just before we commence with our webinar, just a few rules before we start. Please note that you can see us, and unfortunately we cannot see you, and your mics are muted, but should you want to ask a question, you can ask a question on your page view below in the Q&A section. And once your question is answered, it will write on your screen that your question has been answered and you have been sorted. We do note that this webinar will be 40 minutes, so there might be questions that we don't get around to responding to, but we'll make sure that, as we did the last time around, in the next couple of days, we will put on our website your questions together with answers. And if we do not have answers for you as the National Arts Festival, we will point you in the right direction. So we have you covered. And then the other issue is, I know that people have a burning desire to speak about their intellectual property and a lot of industry issues and policy issues. And as much as we'd love to cover all of those, we'll try and cover as much as we can, but I would really love for all the participants to zoom into virtual National Arts Festival and what this means to them, because the festival is just around the corner. I don't even want to start with doing a countdown. Someone in our office started doing that, and it just makes me so nervous that we are less than 50 days away from the virtual National Arts Festival. So I would really like to make sure that artists and our stakeholders do know what to do. And our closing date for applications is on the 15th of May. So the closing date is just around the corner. So without further ado, I would like to introduce our panel to you. And I'll start off with Jade Bowers. Jade Bowers, who is a producer and a director and a production manager from the University of Johannesburg in the Arts and Culture Department. Welcome, Jade. It's so good to have you. And then next up, we have Nothando Mikoko, who's a copyright, licensing, and Africa. Welcome, Nothando. Nothando, can you hear me? Yes, okay, there.
Oh, yeah.
I've got a wave.
I can hear you now.
Yeah, perfect. Okay. Cool. And then we have Chola Makgamathe, who is the General Manager of Legal Services at SAMRO. Chola, welcome.
Thank you, Nobesu.
And then lastly, but definitely not least, we have Elroy Bell, who's a supervisor of theatrical and visual art and general licensing at DALRO. So Elroy, welcome. It's so good to have you on the panel.
Thank you. Thank you
Thank you so much. Thank you so much, guys, for honoring our invitation. We really need your services right now, because as I said, we are less than 50 days away from the virtual National Arts Festival. I just want to dive in. I don't even want to waste any time. And my first question is for you, Chola. Can you please provide us with a brief overview of the work that SAMRO does and how it impacts on the lives of artists?
Okay, I'm going to try to be as brief as possible for something that's quite long to explain. But essentially, SAMRO administers performance rights for composers and authors. Now, what the Copyright Act does is that it's a balancing act between the right for creatives to create their work and also the users to use that work, but also be able to compensate the creatives for that work. So that's the balancing act that the Copyright Act tries to maintain. Now, where an organization like SAMRO fits in is that we're the middleman really between the creatives and the end users. And we are what you call a collective management organization, or in some circles, collecting societies. And in that part of the value chain of administering copyright, we are one of a number of CMOs. So for instance, I mentioned that we administer performance rights. So that's what happens when you perform a composition in public, whether it's broadcast, whether it's streamed, that's a public performance. And that's a right that you have under copyright. You have another CMO called Capasso that administers mechanical rights. You have an organization called IMPRA that administers needle time rights, that really deals with performers in the music space and deals with administers the rights for sound recordings. So there's a distinction between compositions, which SAMRO administers, so compositions which would include musical and literary works, and sound recordings, which an organization like IMPRA would administer. Now, SAMRO and Capasso have the same members, which would be composers, authors, and publishers, but we just administer different rights. So essentially, we're the middleman, but we also take the hassle of dealing with all the administration of getting usage reports from users, licensing users, processing that information, and then obviously making payments to royalty payments to our members who are composers, authors, and publishers at the end of the day. So we take away all of that hassle from composers, authors, and publishers so they can do what it is that they need to do, which is to create works, which they can then exploit commercially and make a living out of it.
Okay, Chola, as you said, it's really difficult to try and explain such a huge organization that does so much work in so little time, but I think you've really summed it quite well. Thank you so much for that. Jade, I'm going to come to you, a woman who wears multiple hats. You are a producer, you are a director, you are also a production manager for University of Johannesburg. So my question to you is, explain to us the importance of copyright licensing from your perspective as a woman who wears these many hats.
Sure. For me, and I think for a lot of people, it's really about ownership and being able to know that you own the work that you do, and to honor the artists who've made that work. You know, to really see the intrinsic value of artistic work that can be used in so many different ways. Does that make sense?
It does make sense.
But to really put in, to know that this person has put in their own creative capacity, their time, knowledge, skill, training into the value, and to keep our artistic community going, and for them to be able to be compensated for this work. Yeah.
So is this a process that you would advise to your fellow artists?
Yes, I mean, I think a lot of it is about being able to know what your rights are as artists. What tends to happen is I get a lot of calls after the fact when everyone's in trouble, going, what do I do now? From friends, from colleagues, from people that I work with in so many different ways. So if you don't know what your rights are, you can't protect your work or know how to. And I'm
Thanks,
sure
yeah. Thanks, Jade. You know what's interesting? I saw Elroy and Chola, they're nodding, because we get to deal with the aftermath all the time. So I guess the nodding means they agree with you. They've been through issues like that. So Elroy, I'm going to come to you now, which I'm going to ask you a similar question to that of Chola. Where can you explain to us what DALRO does, and how does the work of DALRO impact the artist's livelihood?
Okay, thanks, Nobusutu. So DALRO is the Dramatic, Artistic, and Literary Rights Organization. So we're a rights management agency that specifically deals in copyright and licensing for the theatrical, visual arts, and literature fields. So we work with a range of creators and rights holders, visual artists, authors, playwrights, publishers, and we manage the licensing process as it pertains to various industries like theater, publishing, educational photocopying for universities, film adaptation from plays and books, and broadcasting and online hosting of theatrical or visual artworks. So we represent South African creators locally and internationally, and through what are called bilateral agreements, DALRO also represents a vast array of international artists, playwrights, and agencies for South Africa and parts of Africa. So DALRO facilitates the licensing process, that is to say the licensing, contracting, invoicing, and royalty distribution on behalf of artists and authors. We are generally the first point of contact for people interested in performing or publishing copyright protected work. These are often schools, theater producers, publishers, advertisers, auction houses, and while we don't represent everyone in the field, we've been doing this for such a long time that we're often able to advise producers on who to contact should we not have a mandate to represent that creator. So while a license per se is essentially the permission granted by a rights holder, DALRO focuses on monetizing that permission for the benefit of the playwrights, the publishers, and the artists.
Wow, thank you. Thank you so much, Elroy. I know that there will be a number of questions that are asked, particularly by people who are in institutions of higher learning. There is a bit of a discomfort to lecturers when they are using artist work where they don't know whether how to obtain the rights and which works they need to obtain the rights for. And I see that we have 116 participants that are listening to us today. Thank you so much, guys, for joining us. Notando Sisi, I'm going to come to you now. Can you explain to us the work that Sosela does with particular reference to copyright?
Okay, sure. So Sosela is a strategy and legal advisory firm. We've been going for actually a year now. It's exactly a year. And we work in the entire value chain of the creative and copyright process and industry. So right from the creator, the author, all the way to the final user, we're able to provide services to any of those participants. Our core values really are about bringing a positive impact to that entire value chain. So from a benchmarking perspective, from a fairness perspective, from a knowledge sharing perspective, we're very passionate about that. And in terms from the copyright specific work that we do, just looking at the projects that we've worked on over the last year, we've done work for an organization where we did market research at a national level, where this organization wanted to roll out a product in South Africa to a specific copyright user market. We've worked with CMOs, Chola and Elroy, we're talking about CMOs, Capasso, SAMRO, etc. But we're working with the CMO outside of South Africa, where we're engaged to do a company review and assessment from a governance and efficiency perspective. We currently engaged by clients to monitor policy and legal developments, the Copyright Amendment Bill, performance protection, as well. A very interesting project that we recently got where we're looking at the Indigenous Knowledge Systems framework for an organization that wants to create an audiovisual work, but using traditional cultural expressions. So the legal frameworks around that, where does the copyright and the trademark laws, where do they come in? A lot of drafting work that we do, negotiating, agreements for our clients, whether it's, publishing agreements, sponsorship agreements, the kind of daily sort of your more legal stuff. But the value add that we want to that we bring to our clients is really that we'll give the legal aspect, but as well look at the commercial and strategic aspects. I mean, right now we're in this COVID situation. What must happen now, you know? So our clients, we engage our clients on, okay, what are the alternative revenue streams? What are the legal frameworks that hold those? I mean, that's why this webinar is so relevant, because it's not just a philosophical question. It actually is a very relevant, urgent question. How do we leverage online exploitation and ensure that everyone in that value chain benefits? So just in a nutshell, I mean, we work with production houses, we've done work for grand rights, for theaters. Copyright is huge. I mean, the entertainment space is huge. So yeah, that's in a nutshell what we do.
Thank you, Nothando, for that. You've really summed it up so beautifully. But again, the follow-up question is also for you. When we are then contracted by the likes of National Arts Festival, and now we must sign this contract, what is it that you would suggest that we look for before we sign this contract as artists?
And I hope you can hear me. I hope the lag or the delay isn't really terrible. But I mean, I think everyone, can you hear me? Firstly, let me ask that. Am I good?
Yes,
okay, cool.
You're good.
Thank you. I think, artists, everyone, but artists need to take a step back and what is a contract? When you enter into a contract, what are you actually doing? The truth is that you're getting into an agreement where you're giving away and accepting obligations, right? So in any engagement where you're interacting with someone and you're committing to do something and you're committing to be bound by something, you wouldn't just do that unless you understand those obligations very well. And I think that's the first thing that, as a matter of principle, that people need to understand, that if you're signing a contract, you need to understand exactly what you're committing to and exactly what you're being bound to. But I think in any contract that you'd look at, obviously there are different clauses that one needs to look at, but a few key ones, which I think are the ones that trip people up eventually, if they don't really understand. I mean, I would look at key issues are like the term. How long is this contract? A lot of people think, I'm signing a 2-year contract, but actually there are options and things. Next thing, you're in a 10-year contract. You thought you were signing a 2-year contract. So it's very important to understand, how long am I going to be in this arrangement for? And that's, the term. And the current, or let me not even go into the amendment bills, etc., because that looks at terms and that, but term important. I would also say, ownership. Another thing that people don't really understand is that they get into contracts, and now I'm talking more maybe your music contracts, where people down the line, they're like, no, but my song, and then they realize, no, it's not, you don't own that work. You think you may have written it, but you don't own it. You need to understand what that agreement talks about ownership, because that will determine what you're able to do with that work or not able to do with that work in the future. Things like exploitation. So what am I allowing the person I'm contracting with, whether it's a production house, whether it's a record label, whether it's a publisher, whoever, what am I allowing them to do with this thing that I'm putting in this contract? So whether it's a play, whether it's a song, whatever it is, what am I allowing? Am I allowing them to be able to do anything with it? Because then if I'm giving them all unfettered rights, I can't complain when they then take that song and they put it somewhere and I'm like, but I don't really like that. And they're like, no, but it's you gave us those rights. So it's really understanding. It's very difficult to look out for this, and this, because it varies. It depends on what the contract is. But I think the principle of you're getting into an arrangement where you're giving something away. Do you understand what you're giving away? If you don't understand what you're giving away, then don't give it away. You need to make sure you understand what that is. Do you understand how you're going to get paid when this work is used here or is played here? Are you getting 50%? Are you getting 12%? because once you've signed that, you can't come back and say, oh no, but then I thought it was 50-50 because that's what we know. Like, you need to be able to understand those things. In music contracts, label contracts and publishing contracts, a big one is also issues around advances and recoupments. I always say to people, be very mindful, you know, $1 million, you know, bar up front, R1 million up front is great. But if you're going to be repaying that R1 million for the next 3 years and not earning any revenue because you've got this debt, you need to understand that up front, you know. So it's whole issue of consensus, I think. You know, in contract law, you talk about consensus. Do you actually understand and agree and are aware of the intention that you have in signing this contract? Everything else then just flows. Because, I mean, you have people come to SAMRO and DALRO and like, no, guys, where's my money? My money. And then you look at the contract, there's nothing there. In fact, you know what I mean? So it's that. And that's where really you need to get professional advice. I can't, you know, I'm not going to build a house and look at architectural documents without talking to an architect and saying, do these plans make sense? You know, if you're in a contract, you need to speak to a lawyer to make sure that you understand what you're signing. I think, yeah.
Thank you. Thank you, Nothando. I think what I got from your response is that the contract, a contract issue, any contract issue is not a child's play. If you do not understand contract, get someone who does. Because sometimes as artists, we don't understand what we're getting ourselves into, and yet really this is our intellectual property. This is something that we have worked on for so long, and when we sign on that dotted line, sometimes we just go to the last page, which is normally where remuneration is. And we quickly sign, and then you find out that actually you don't own this work after you've been compensated. On that, Elroy, I'm going to come. Okay.
No, I was just going to say, just
you
know, cut me off. It's fine. Carry on.
I am cutting you off right there. Mute her,
Madam Chair.
Elroy, I'm going to come to you before Nothando takes this opportunity. Elroy, can you give us, you know, some quick practical guidance in terms of applying for license to use one script or some other material, and also registering your work at DALRO, and instances where performance rights licenses are not applicable or are not required. Can you explain that to us?
Okay, you've given me quite a lot to cover. Thanks, Nobasutu. All right, so applying for licenses to publicly perform dramatic scripts or publish an image of a work of visual art on an online platform or in a book, for example. These are generally easy processes. The first step is simply to contact the rights holder or the agent responsible for that work. In many cases, I mean, you're very welcome to contact DALRO if you don't know, because we generally have a system of checking and doing research around that, and we represent a number of publications and visual arts works. And that can be done through, I mean, if you don't know, you can always just contact DALRO's DALRO through the website dalro.co.za, or just emailed our department directly on our email, which is still theatricals@dalro.co.za. In that, you'd indicate what you're intending to do and what work you're intending to use. And we've worked hard on getting to a maximum of 24-hour turnaround time to get back to you with a form of questions to understand what the exact scope of that use will be. This info is then used to clear permission with that rights holder. Once permission is granted, DALRO will send the applicants the terms and conditions, as Nothando was talking about, which govern the license as it pertains to that use, as well as any quotes related to any fees which may be due. But I think it's also important here for me to just mention adapting work, and I'll probably come back to this again a bit later, but adapting work is also an important right that I think is prudent here. Because for example, anyone who wishes to translate a work, adapt a prose piece into dramatic text, video record a public performance of a licensed work, or stream it for that matter, is essentially creating an adaptation of that work. Under SA copyright law, that is an enabling right, and it must be granted before that adaptation takes place. So before you write your first translated word, or before you even think of recording that, that public performance, the license needs to be granted beforehand. So what does that mean? For example, should you wish to do a radio play, that is an audio broadcast of a written copyright protected play. You would first need to seek permission to adapt the written play into audio format, because that's the new adaptation. This would be done through a written authorization from the rights holder or the agent, like DALRO does this for all its rights holders. Once that adaptation is created, that work is then licensable and has a particular split as negotiated by the rights holder or the rights agent. And it would follow the same process as I'd mentioned earlier in relation to licensing a work. We'd need to know the scope of the intended exploitation of the work, how long the recording may be as it pertains to this example, what protected platform would be used to exhibit the work, how many times it would be broadcast on which channels, etc., in order to create a holistic terms and conditions license, and a similar licensing process would follow. So on the point of registering with DALRO, DALRO operates on a mandate basis. So we have a range of non-exclusive representation mandates, which authorize DALRO to license and collect royalties on a rights holder's behalf. Ultimately, DALRO cannot legally represent an author or an artist without such a mandate. So it is important to note that DALRO never owns a creator's IP. DALRO only administers these rights on behalf of that creator. So it is also a non-exclusive agreement, so owners can also manage their own licenses independently as they see fit, though these are, those non-DALRO licenses are not enforceable by DALRO because they weren't managed initially by DALRO. We ultimately aim to give our represented authors and artists flexibility. So the process for that is quite simple. Again, just dropping us an email, contacting us through social media or our website, or dropping us an email to our department. The easy email is dalro@dalro.co.za. We then supply the author, artist, or publisher for that matter with the relevant mandate. They'd need to review it, have it reviewed by a legal professional if they see fit to do so, but they need to understand what's in that contract, because we are administering the work, and we will consistently check in with them to clear permissions. But it is a legal relationship that they're entering into with an organization, regardless of whether it's exclusive or not exclusive. And they need to sign it and return it to DALRO, but also with an accompanying certified copy of the ID, as well as a letter from their bank confirming their bank details for the purposes of paying any prospective royalties. And that's it in terms of registering for licensable, to be licensed by DALRO. And then I think the last question was when we're considering works that may not be require permissions or licensing. Yeah. So firstly, if you're producing your own work, you obviously don't need to get permission. But unless you're the minority owner in a work which you co-created with other people, or you've ceded your rights to someone else, as Notando was alluding to earlier, then you would need to seek permission even if you wrote it. So it would require, you would need to know if you at some point signed an agreement where you ceded your rights to someone else, or if you co-created and you're the minority owner of that work, you would need to seek licensing for that. So separately from that, copyright has a lifespan. So in South Africa, this expires 50 years after the death of the last author or artist who contributed to that work, or 50 years after the publication of that work. So it should be in public domain if it doesn't fall into those categories, and you should be able to use or adapt the work without a license. That being said, there is no harm in checking if you're not sure, because I think it's safer to know if than to be caught out along the way. And you can easily contact an organization like DALRO to find that out for you and do a little bit of background research for you. We're very happy to do that. We're ultimately just trying to also just make the licensing environment and landscape a little bit more compliant as well. So that's the sort of work we're very happy to do in the background. Because publishers are often republishing new versions and editions and adaptations and anthologies of work. So particularly with Shakespeare and Greek classics, etc. So you'll need to be sure that the publication that you're planning to produce, the specific publication version that you're using, is indeed out of copyright if you are seeking for a public domain version of that work. Because if it's not out of copyright, it will still be liable for licensing. Ultimately, as I said, my advice is better to be safe than sorry. And if you're not sure, just ask. And there are organizations like DALRO if you're specifically looking around theatrical producing. So yeah.
Thank you. Thank you so much, Elroy. We are now 31 minutes into this webinar. And yes, Notando, yes, 31 minutes into this webinar, and it's meant to last for 40 minutes. Just a reminder to the participants, please kindly write your questions on the Q&A section below your page view, and we'll try and get to everyone on the webinar. But if we don't get to your question, as I said, we will publish the questions and answers on our website as part of the frequently asked questions. Chola, we are 31 minutes in. Just a reminder. I'm going to ask you the same, a similar question that I asked Elroy. If you can help us understand the practical terms on how to apply for licenses to music recordings and how to register your music with SAMRO.
Okay, I will try to be as brief as I possibly can. So from the licensing perspective, there are a number of ways, right? And this is because we have a number of users. You have broadcasters, you have shops, you have malls, you have restaurants, you have a whole number of users that we want to use our members' works for whatever purpose. So what we've ended up doing is that we have a large number of tariffs per different user, which will indicate what the ultimate license fee will be. Now, there's some people who are very proactive and unaware of what their obligations in terms of copyright, and they will either approach us directly, either contact our licensing team on email, or go to our website, because the different licensing categories are there on our website, and the license agreements are there, which they can download and then fill in the requisite details, and then subsequently contact the licensing team so that we can conclude a license agreement with them. Generally speaking, they are standardized agreements, and most licensees will be fine with the terms thereof. Take into account a seating capacity, square meterage, that kind of thing. So that's what will generally happen. On the other side, where there are people who are maybe not aware of their obligations, our licensing team is dedicated to going out there and finding new business and educating the market about what it is they're supposed to do or what their obligations are in terms of copyright law. So that's from the licensing perspective, and that's in terms of the tariffs and the parameters. I've just out, because I know you're going to ask later on about online, how we deal with that. That's the traditional, sort of the way that we operate. Now, that's one set of it. With respect to the registration of the works, and I know you keep saying sound recordings. For SAMRO, it's compositions. Sound recordings is SAMPRA or IMPRA. For purposes of registering your works. Now, like Elroy said, we can't act on your behalf if we don't have that mandate. So you would have to assign your rights to SAMRO to act on your behalf. And in that regard, what would happen, pre-COVID, you'd be able to walk into our offices and fill in an application form, sign a deed of assignment, which allows us to act on your behalf in various territories, exclusive or non-exclusive, whatever the case may be, or even carving out certain things. And then you notify at least one work, a minimum of one work. And it's for free. You don't pay us anything for that, and that's what you do. Or alternatively, you call in the call center and they give you the documents, and then you submit that to them. Now, we can act on your behalf and you can sign all of that, but you need to understand also that they are membership rules that you need to abide by. There are all sorts of rules that you need to abide by in terms of your membership with an organization like SAMRO. You also need to understand that we operate in an international context and we have certain obligations. Like Elroy was saying, we have bilateral agreements. We're a member of an international body called CSAC that has certain rules in terms of how we need to operate in order for us to enter into agreements with other CMOs in other territories, which would be able to then collect on behalf of some of our members and vice versa in our territories. Now, that's the registration process for you to become a member of SAMRO. And there are different categories of membership depending on obviously the number of works, the usage of the works, etc., etc. Now, when you're notifying, because if you don't notify your works, right, your works can be used by a user. If you've not notified your works, we don't have it in our system. So, it's difficult to make payment if we're unaware of what you've been doing. So there are a couple of ways you can notify or register your works with us once you've done that registration process. There's the good old-fashioned paper way, where either you walked in and you filled in papers, and that allows a maximum of 30 notification of works. Or in the current situation where you can't walk into our offices, you can send an email to us and then fill in all this documentation, and then same thing, minimum, a maximum 30. Alternatively, you can have access to our member portal, which I think we're running quite a bit of promo on that at the moment, where it's got multiple functionalities, which makes it easier for you to engage with SAMRO. You can register your works there. That allows a maximum of 10 notification of works. Alternatively, electronically, which is what the publishers use, that's bulk notifications, about 50,000 works max that you can notify in that format. So it's an Excel spreadsheet, and then we get that information, which we have on our database, because ultimately we need to match what we have with what's reported by the users and able to appropriately pay you your royalties.
Thank you, Chola. I've got a privilege of being the chair, so I might not go according to script, because I want to ask you a follow-up question, Chola. I've got a production, a dance production, and I'm using someone's music in this dance production, and I'm going to broadcast it online. I'm going to stream it live online. And how does SAMRO then calculate the royalties that need to go to the musician? Because we know that SAMRO usually uses the ticket fee. It uses the capacity of the venue and so forth and so on. But how do you then calculate it when we are talking about an online platform?
Okay, so you need to delineate the two. So there is the licensing component of it, and then there's the distribution component of it. And the distribution component is what's ultimately paid in terms of royalties. So when we're licensing what we call digital service providers, there are a couple of different models that we look at. One of them is on a subscription basis, and then we charge a percentage of revenue for that. And then there's also ad-based for DSPs or free. So it's either that is minimum value per users, or for the freemium, we call them, you charge per play. If it's online radio, it's based on the number of users or a percentage of radio. So depending on the DSP and the negotiations and the terms of the contract, there are different models of pricing for the license fee that will come out of that. Now, once we have that license agreement in place, and also there's a webcast platform where you use your own platform. You don't necessarily use a DSP for that work. There, you're either looking at a percentage of revenue or a fixed price per ticket. So in your instance, if you're using your own platform as the National Arts Festival, either a percentage of revenue or a fixed price for tickets, whatever it is that you negotiate with SAMRO / Capasso in that regard. So that's generally it. So it's all dependent on the platform and the parameters of the contract with that platform in terms of what use they require. Then there's a second component of the distribution of those royalties. So what happens is that the DSPs are required to provide us with usage information. So to tell us what what repertoire they actually used
Mm.
during that public performance. We then take that information and we factor in our, and this is just very broadly speaking, it's a very detailed process, but very broadly and generally speaking, we then factor in our administration fee because we are administrators, and which we could look at things like, and also look at the duration, the number of plays, etc., and then on the basis of that, subsequently distribute. Now, not every DSP pays the same fee, and the usage is different, and ultimately the royalties paid obviously is dependent on the usage. So for instance, if your work has high usage, then it makes sense ultimately that you'll get paid a larger royalty. If it's not, then it factors in ultimately at the end of the day.
Thank you so much, Chola. Thank you so much for that. You've really made it so clear for us. So we are now 41 minutes in, and I'm going to plead with our participants and our panel that we extend our time because we still have quite a number of things to get through. And please note that when we have answered your question that you have asked, it will indicate on that Q&A section that that particular question has been responded to. Jade, I'm going to come to you. Wearing your hat as an artist, you spoke about the importance of copyright and licensing for our work, but what are some of the common and general misconceptions around these issues? What is it that we sometimes get wrong and we don't understand, and sometimes we think we're right? Can you have a bite on that for us?
Sure. So I wrote down a few, and I'm not sure we'll be able to get to all of them.
Go for it. We are extending by 15 minutes, so we'll end at 5.
So the first one that I've got here is registering your copyright. You don't need to register your copyright. If your work exists in a format, in a physical format, whether that is a video recording, whether it is written on paper, whether it is written on your computer, any physical format, your work then holds copyright. You do not have to register with DALRO or SAMRO. What they do is administer that right on your behalf. So they collect the money on your behalf, but it is not essential for you to register with them to own your copyright. You still own your copyright. The next one I've got is fair usage. Fair usage becomes such a gray area. And I often hear things like, oh, but I'm only using 30 seconds, so it's fine. Where the act doesn't actually specify a time. So if you don't know, if you want to use someone's work, ask. If they say no, don't use it. Then the next one I've got is educational purposes. So when I was working at DALRO, this was also a very big question for exam work specifically. If you have an audience, you need to pay a licensing fee. So if it is only within a classroom and the people, or for an exam where only the examiner is there and maybe your class, then you don't need to pay a licensing fee. But if you have any type of audience, whether it is a paying audience or a free audience, you need to pay for that work. Adapting, translating, yes, you still need permission. You're still taking somebody else's work. You're creating a whole new work, which is a whole other contract that you need to go into, but you still need permission. And the original work will still hold the biggest percentage of the copyright. Commissioning work. So the Act provides provision for commissioning work. For example, if somebody pays you, they say, look, I need a song for an ad, or I need this play written for this festival and I'm going to pay you X amount of money. Please look at your contract. Please make sure you have a contract before you start working, because if it is seen as a commission, within the Act, it states that the commissioning party then owns the copyright. If you want to hold onto your copyright, please make sure you have a contract that states the copyright will stay with you. And if you want to keep it, like, know exactly what everyone's been saying before. Make sure you have a contract, make sure you understand the contract, so that you know what you're signing. Very important. I think the biggest thing that I've got here is, if it's not your work, ask.
Yeah. If it is not your work, ask.
And the last one I've got here is workshopping work. I mean, I think within theater groups, it's become quite a common way to create work. And people are normally doing it with their friends, and then they don't do a contract, and then it starts to make money, and then there's a problem. So please make sure you go into an agreement. Please make sure you write it down, even if it's on an email thread or on a piece of paper and everyone signs it with a date. Know how much each person is getting out of that. There's often, what happens a lot is like, a work gets made and it's all fun and it's all in friends, and then 5 years down the line, maybe 10 months down the line, it wants to be made into a set work. Then people are talking money. And then the friendship dies, and then there's no more contract. So know who owns what and how much percentage is being shared. Elroy is laughing because I know he's sat with the same things before.
Yeah, haven't we all experienced these? Thank you so much, Jade. Notando, I'm coming to you. You spoke about the importance of contracts and how we must go through our contracts and interrogate them and know exactly what we are signing ourselves in, or if we are signing our lives away. So can you give us practical examples of what can go wrong and the consequences of not ensuring that contractual and licensing obligations are in place?
Yeah, I think fortunately in the previous long monologue, I did actually talk about some of the pitfalls of not getting your contracts right, particularly from an artist perspective, and it's really usually in those two situations. One, when the work gets very successful, so like what Jade was talking about, now the song is huge, or the play is being, it's a set work, but there's no split sheet, there's no this, then that becomes a problem. Or the other part is when the artists fall on hard times, then it's a matter of, no, but where's my money? But the contract doesn't allow. What I didn't touch on though was where the contract is not in place from a user perspective. And I'll just give a quick practical example of something that the general industry found itself, the collective management industry found itself in, when we had these agreements. The CMOs had agreements with broadcasters for terrestrial broadcasting. So for SABC or for Mnet, whatever, to broadcast on terrestrially, but like normal broadcasting. But now then they started coming in with digital and online streaming of programs. So you're now able to watch what you watched on TV. You can watch it online, you can watch it on catch up, you can watch it on streaming platforms. And the assumption that, no, but we've already got a license to do this. We've already got a license with SAMRO, we've already got a license with Capasso, but that license does not allow you to stream. It allows you to broadcast on terrestrial broadcasting. So that was a practical, very simple practical example of how, when you don't have the right, you may have an agreement, but the agreement does not extend to all the uses and exploitations. So understand that whole understanding the exploitations that you may have in your contract. And when now you want to do something outside of your contract, ensuring that you get the requisite permission.
Thank you, Notando. So, Elroy, I've got one last question in this round for you. Before we ask you the questions that our participants had sent to us prior to this webinar, and we're going to do this interchangeably. So we'll take one question from participants who sent us their questions prior to the webinar and those who are here now. So I'm going to ask you, Elroy, the last question for this round. So can you tell us, a visual artist who wants to be part of the virtual National Arts Festival, but they're not sure of how the use of visual art, image, and graphics is governed, particularly online. Can you assist with that?
Yeah, so the short answer is this, the reproduction of visual artwork is governed by the terms and conditions of the license. So if the festival is licensing the hosting of the image of visual artwork on their platform, that license would need to include the particular URL that the image is being hosted on, the maximum pixels that the image is allowed to be hosted at, the time period for which the license is valid and that the image is permitted to be hosted on that particular site, as well as any particular attributions which might need to be included alongside the image. For example, if I'm using a Blessing Gobeni work, I'd need to include a copyright symbol with the year and his name and the authorizing body, which in this case would be DALRO, accompanying that image to prove that it is a licensed sort of usage. The license will also extend to any decisions the artist and the producer decide upon in relation to protections. So that would mean, that would include watermarks, a disclaimer prohibiting image scraping from that site, or any other protective measures agreed to between the producer and the exhibition and the artist.
Thank you. Thanks, Elroy, for that. The next question that I have is for you, Chola, and it is from Jackie Renz. And Jackie is asking about this new thing that you find that people are uploading videos on various platforms online, and they have this disclaimer that says, "I do not own the rights." Is that okay? Is that permissible to use the song without the license or rights? Is it an okay thing to do? Because it's quite in. It's a fashionable thing that people are doing lately.
The thing is, you might not own the rights, but in order to use them, you need to get a license or get permission from the rights owner. So you can put that disclaimer, but if you haven't followed through with what you're supposed to do in terms of your obligations, then what you're doing is in violation of copyright law. Now, what people need to be careful of in that situation, and even in an instance where you do have the license or you've gotten the permission, is that the terms and conditions of that platform might prohibit you for some other reason from using those works, and they can actually take down those videos. So even in an instance where there's streaming, for whatever reason, in terms of those terms and conditions, the streaming can be stopped by one of those platforms because whatever has been the content upload or the streamer has not followed whatever terms and conditions are in place, or maybe there's a trademark violation, or there's just something that has not been done correctly. So you can go through the whole process of getting a license with us, but there's something else that you have not done properly in terms of the use of that platform that would happen in that instance. But to answer the initial question, that disclaimer does not free you from meeting your obligations in terms of copyright.
Okay, thank you, Chola, for that. So now we're going to take a question from the participants, and this is from Stuart Palmer. He says, "Hi, in place of doing our usual educational theatre in schools, we at Lunchbox Theatre have produced 10 short COVID-19 informative videos that we have released on Facebook and YouTube. They have been viewed over 100,000 times online. I'm happy for the videos to be shared, and I encourage that. But I would like to know, how can we secure these so that others cannot abuse them by claiming them as their own, using experts, or falsely capitalizing on them?" Elroy, can you take this for us?
I can try. Yeah. So I mean, ultimately, you need to understand that. Firstly, you're posting your work onto a social media platform which has its own terms of use. So before and this is the same conversation I have with a lot of visual artists who are marketing their work through Instagram and Facebook. The moment you upload, you are abiding complicitly to their terms of use. And that allows for a wide range of sharing without licensable income. So you need to, and it's the responsibility of that creator or the poster to be aware of that before they enter into any of those sorts of posting. I'm not saying you shouldn't, I'm just saying that you need to balance the risk accordingly. So for short clips like this, I mean, I don't believe that there is necessarily a way to register them, because I mean the CIPC would be able to register films as related to a particular thing, but short clips like this, I'm not entirely sure how they'd be able to claim. Well, you can claim ownership because of the historical evidence online related to the fact that the first time this was uploaded was by you, and then if it's abused in any way, you can then seek sort of copyright infringement, retrospective licensing, or damage claims or something like that. Yeah, it does require the people who are using social media as a platform to upload things to be aware of the terms of use that they're engaging in.
Thanks, Elroy. When we spoke about visual arts, you spoke about the issue of watermarks, but now Emma is asking, does putting this work on public platforms in any way negate the copyright of the work? And are there ways to watermark these videos so that people can't cut clips without acknowledging the makers? So moving away
ways,
now, yeah.
So yeah, there are definitely ways to watermark both video as well as images, and that does inhibit widespread scraping, so to speak. But the easiest thing, particularly with online festivals and the streaming of live work and live exhibitions, is to host these things on protected platforms. So there's a concern related to the ability to download easily off of YouTube, for example, which is a concern for us as we are now developing or digitizing a lot of work in order to give access to a wide number of people in light of COVID. And we are encouraging a number of producers and anybody who is coming up with very innovative projects to use any protected platform they can in order to exhibit these works, not only to protect the integrity of the work and the ability for it to be reproduced against the author's will, but also to find innovative ways to monetize the work, so that as much as we're all trying to get access, there's a balance that needs to be struck between access and income for artists and creators. So it's not only about providing it for free, but we need to change a mindset to people that are using works to allow them to understand that even though it's online and it's on my screen and I'm watching it in my home, I should pay for this because I did not come up with it. So, and even if that's a nominal amount for school kids of like 10 Rand per view or 5 Rand per view or something like that, it's a mindset that needs to change in order for the value of the art to be understood and appreciated.
Thanks, Elroy, for that. Notando, we have a question for you from Stephen Sack, asking if our current intellectual property legislation and collection agencies, are they adequate enough to the task of managing the expanded market and legal particularities of online content?
You know, from a legal framework perspective, from the IP legislation, that has lagged behind. And this is why we've got the Copyright Amendment Bill that is currently in process. But actually, our organizations actually went, and the practice in the industry went ahead of the legislation. And even though we don't have the, you know, in the current law, the right enabling legislation for online exploitation and all of that, practice has taken over years ago, and we've been licensing digital service providers, we've been licensing streaming, VOD services, etc., based on international benchmarking. And I think all the users, fortunately, understanding the global environment that we are in, is that even if our domestic legislation hasn't been up to speed, they accept that we, you know, that they are licensable. So we've been, and at quite, I think I would say, robust, favorable rates, been able to engage and license users. So definitely from a you know, practice perspective. But I think what does remain a challenge from a practicality perspective is just like technology, and it's not unique to South Africa. This is an international issue, just the technology. You know, you're licensing the most robust technological leaders, you know, the YouTubes, Apple Music, and these are the guys that are actually driving technology, and you have to now license them, process their data, you know, you're like almost a step ahead because we're not, you know, as an industry, not necessarily tech industry. So I think that's just the challenge and getting up to speed. But I think we're okay. I think South Africa is it's okay. There's always room for improvement, but I think the industry has remained robust enough to keep keep pace with the developments in this area.
Thank you, thank you, Notando. Stephen, Jade is asking, what are the opportunities and rights issues for product placement as a new revenue stream for online content? Can you assist him with that?
Sure. I don't really have experience in product placement. I've never done it. And the question feels a little bit vague about what you're actually asking about product placement. So it depends on the agreement that you have. So, I mean, yes, times are very different all of a sudden, and we're all trying to kind of hustle to find ways of making money through what we do. You would need to be very specific about what your agreement is looking like. And what you're willing to give for that product placement. So if you're going into an agreement with, you know, Coke, for example, and you need to use Coke in an online video, do you know if you will still own that video? Or will Coke be able to take that video and do whatever they want with it? Are you able to keep your creative integrity, or do you have to do exactly what they're saying? Like, just know what you're signing. And then also, if you're using work that is not yours, so if you have a writer involved, if you have a composer involved, for example, who has to create the work and you're producing, does that work need to be adapted in order to get the product placement on board? Like, does it have to be part of a storyline? And are your writers willing to do that? Are they willing to have their work adapted? Is that part of the agreement that you have with the writers? So what is the degree of the product placement? Just know what you want out of it and what you're willing to give for it.
Thank you. Thank you, Jade. Chola, this is our last question. Unfortunately, we cannot keep on going. I would go on for another 30 minutes, but I think the participants and probably my panel will kill me because we've already gone over time. But Chola, this last question is for you. And for me, it feels like it's issues that we've dealt with before, but maybe our participants would love for you to reiterate some of the issues. This question is from Andile Kongo. The first question is, do web-based platforms subscribe to copyright rules like physical venues?
Sure. To web physical. Okay, no, I'm not sure the question is
web-based platforms. Do they subscribe to copyright rules like physical venues?
Oh, I see what you're saying.
Yes,
sure.
yes. So this theater, we need to make sure that we subscribe to copyright rules and all of that.
Yeah.
And what web-based platforms, do they subscribe?
Look, I mean, I think it depends. On the whole, like Notando was saying, we've been very robust in terms of getting a lot of web-based platforms licensed. So where, for instance, they approach us directly, great, but in a lot of instances, you'll find somebody will launch a platform and not, depending on the scale, understand what the obligations are in terms of copyright. And then you find in some instances that the larger ones do try and take chances because our copyright legislation at the moment does not take into account a lot of this digital exploitation. So they try to limit the scope of what they can pay for in our jurisdiction, whereas they will meet their obligations in other jurisdictions. So that's where usually the fight is. So for instance, in the Copyright Amendment Bill, the draft provides for digital rights, which are communication to the public and making available to the public, which are not in the current Copyright Act. And you find that a lot of larger platforms don't want to license for those particular rights, but only license for the rights that are in our current act, but they'll comply with copyright legislation in other jurisdictions where those rights are in those legislations. So it's an interesting one, because there are those who will comply fully, but there are those who will try. I mean, everybody's trying to get a good deal for themselves, who will try and limit how much they will pay for a license fee. But also the physical venues themselves are not necessarily always compliant. They also are quite difficult to chase, and because there's so many of them, capacity becomes a problem. So there are challenges with both, but we are proactively and aggressively trying to do what's in the best interest of our members at all times.
And I think you have, in this response, Chola, I think you have responded to the next question of Andile Kongo, who is saying, are our music royalty collecting societies equipped to collect from platforms like Facebook, YouTube, and Twitter?
Yes, they are.
Yes, they are. Andile Kongo, yes, they are. Ladies and gentlemen, we have come to the end of this webinar. I'd like to take this time to thank you so much, Notando, Enkosi Chola, Bayadanki Elroy, Siabulela, Jade, and thank you so much to the National Arts Festival team who are working behind the scenes. We really, truly appreciate your effort. So in our next webinar, we'll be talking about the technical aspects of making online content. I think it might be very helpful to people who have ideas and who are still to submit for the Virtual National Arts Festival, to actually get to understand how to make this online content. From myself, Nobesu Tukhai, thank you very much. We'll see you next time.
Thank you.
Thank you.